Welcome to the Data Stream, the podcast that dives deep into the fast-moving currents of data, technology, and the law. BakerHostetler's Digital Assets and Data Management Practice Group, DADM, brings you this series. Hosted by partners David Sherman and Nichole Sterling, to explore how companies navigate the complex and often intertwined lifecycle of data, from privacy and cybersecurity to advertising, AI, and other emerging technologies. I'm Charlie May, and you're listening to Baker Hosts. On today's episode, David and Nichole speak with Melinda McLellan, co-leader of BakerHostetler's Privacy Governance and Technology Transactions team. An experienced privacy advisor, Melinda works with global organizations on all aspects of privacy compliance. In this episode, Melinda breaks down why a nearly 35-year-old law, the Telephone Consumer Protection Act, or TCPA, remains such a concern for companies today.
Welcome, Melinda. Thanks for joining us today on the Data Stream. We wanted to talk to you a little bit about some interesting things happening with the TCPA, but first, we want to talk a little bit about your career. So you've built a career at the intersection of law, technology, and privacy. And I understand that your 20th anniversary as a lawyer in New York is coming up soon. So can you tell us a bit about how you've seen the practice of privacy law evolve over time?
Sure, yes. And I actually think my anniversary might be this week. I did start in September of 2005. And at the beginning, I was not a privacy lawyer. I was a baby litigator for a few years before I moved over into privacy law in 2008. And when I first started working in privacy law, a lot of people, myself included, weren't even exactly sure what that was supposed to include or what exactly that meant. And at the time, the universe of folks who would have said they were privacy law practitioners and could have seriously meant it was much smaller. And there were a number of federal and state laws on the books at that time that could have been considered privacy laws and may have been considered privacy laws, such as the FCRA, or the Fair Credit Reporting Act, which is sometimes referred to as the original privacy law from the early 70s, or HIPAA. Most people are familiar with that now, but they were even familiar with that then. And it was a logical law to have about health data specifically. And of course, the TCPA, which we're going to discuss more later, which was enacted in 1991. And there were a number of states that had enacted data security breach notification laws. So there was a landscape. But at that time, most people, including myself, had not yet ever received a breach notification letter, which at this point is almost unthinkable. But within just a few years of that, stories about data security breaches and other privacy law issues and just privacy issues generally were front page news every single day. And anyone that I told I was a privacy lawyer knew exactly what I was talking about, or at least had an idea of what I was talking about. And it would be inaccurate to describe this development in the awareness of privacy law or the development in issues involving privacy law as gradual. It wasn't gradual. It was not only extremely quick, but exponential. It blew up, which makes sense in light of how quickly the internet developed and privacy law moved from being something that only a handful of companies were really focused on because data was their business or they were specifically aware of it, to something I could talk about with any client. For a while, it was still on the back burner for certain companies, and we couldn't really convince them to be especially concerned about it because there were a lot of other legal issues that took precedence. They weren't as focused on privacy law. And I think that's where we see some real development, is that there are very few companies nowadays that legitimately would say, yeah, privacy is irrelevant to us. We don't need to focus on how that's being regulated. It is extremely important to almost every business at this point. And a lot of people, when I tell them I moved over to privacy law in 2008, they'll say, oh gosh, you were so smart. It was really right before the crash, right before the economy fell apart. Like, oh, what a great move. That was so smart of you. But I myself did not have any idea how important it would become over time when I moved from just being a sort of general litigation associate to focusing on privacy law and not on the litigation side of it.
Well, you're in good company. I believe we are all recovering litigators on this podcast today. So it's interesting that we've seen such an explosion of these laws in the sort of past few years. And yet we've brought you on today to talk about the Telephone Consumer Protection Act, or the TCPA. which is not one of these recent laws at all, but it has been a major focus of your practice quite recently. And a lot of that has to do with text messaging programs and various other compliance pieces that clients are asking about around the TCPA. I know you also do a lot with biometrics and biometric law, but we're going to leave that aside for today. We'll make you come back sometime and talk to us about biometrics. So for anybody who's not familiar with the TCPA, what is it and why is it such a big deal for businesses?
Well, I actually think anyone listening is somewhat familiar with it, whether or not they've ever heard the name TCPA or know what that stands for, because it is what gave us the do not call list, the national do not call list. And yes, it was enacted in 1991, so it's, a bit old at this point, but it is a law that regulates telemarketing activities. And it has been expanded, and I know that we'll get into this in a little more depth as the podcast goes along, but it concerns calls, and I'm just going to use that term loosely for the moment because it now includes texts that are made for a telemarketing purpose, a purpose of selling or encouraging the purchase of a good or service. It's somewhat broad. It also covers calls that are made by businesses to individuals for informational purposes, depending on how they got the phone number. But at the end of the day, I think the most enduring legacy, or the thing that, especially years ago when it wasn't quite at the forefront the way it is now, we'd say is, the TCPA gave us the do not call list, and there are more Americans who are registered on the do not call list than there are registered voters, which apparently was a statistic that was true at the time. And I don't doubt that it's true now, although I did not check it before this podcast. It was something that immediately was extremely popular. And the reason that it's become such a big deal in recent years has to do with the fact that text message marketing is an extremely effective means of getting to customers for so many businesses. And the marketing teams at our clients want to use text message marketing because it is undoubtedly more effective for them in almost all cases than, say, email marketing or just, ads that you might come across on the internet when you're browsing or something like that. So it is, I think part of the reason it's become such a big deal is that, and then separately because of the class action litigation we've seen in this area.
So you just mentioned, so it's fascinating to think about. So you mentioned TCPA was enacted in 1991. That's like the same year the Soviet Union, I believe, was dissolved.
Yeah, it's squarely a millennial. The TCPA is a millennial at this point, in the middle.
I'm an elder millennial, so I'll take that for what it is. But anyway, it predates mass-produced cell phones and, as you mentioned, right, the internet, public internet. So has TCPA kept up with changes over time? And do you think the history is relevant to how companies handle compliance today?
It has kept up with changes because the FCC was given authority to interpret it, which is somewhat up for grabs at the moment, given a recent Supreme Court decision that we'll talk about in a bit. But it has kept up with changes to some extent, but it still has some of this older language that doesn't necessarily align with how we perceive marketing calls and or texts today. And I think that the way in which I would say it's relevant to how companies handle compliance is in helping them understand where we're coming from, depending on who I'm talking to. I mean, if I'm talking to someone who's around my age or older, I can just say, like, look, this law was enacted when Americans were so frustrated with getting interrupted in the middle of dinner with random calls where they'd pick up and it would be a robot talking to them about a dog care service and they don't have a dog, or talking about getting an oil change and they didn't have a car. Any kind of telemarketing call was happening constantly to all sorts of people all the time. They had no idea how their number had been obtained by these companies. They didn't know how to get out of it. They didn't know how they could opt out of it. And frankly, they didn't have a way to do so. And so that was the environment in which this law was passed. When you look back and read the restrictions on it that specifically target the use of artificial or pre-recorded voices or the use of automatic telephone dialing systems, like what they were thinking about back then was the telemarketing landscape of, frankly, the 80s and then I guess the early 90s at that point. And so some of the requirements and the restrictions do not seem intuitive or don't make sense to clients. Like, why do we have to do this or why do we have to do that? And I tried to help clients understand that the reason it's phrased this way or the reason it's organized this way has to go back to the origins of the law. And it's become such a big deal because the TCPA includes a private right of action, the ability for individuals to claim damages under the law, statutory damages under the law. and therefore for plaintiffs' attorneys to bring class action suits under this law in a way they can't under many other privacy laws that don't have a private right of action. I think that's why it's become such a big deal.
It's so funny. As you were talking about this, and I was thinking back to, again, the origins of the law, I have this super vivid memory of my dad in like the early 90s, absolutely flipping out because...
Slamming down the phone, maybe?
I mean, many of those moments. I mean, that was just my dad to begin with, but like thinking about the answering machine, right? And the tape running out in the answering machine because of robocalls. And when we think about like the compliance risks, again, okay, the law, right, it serves a clear purpose. And then there are, who would the putative class members be? Who on earth, like, how could the plaintiff's bar go out there and find a putative class member or a lead class representative? And I'm sitting there thinking about my dad, like literally about to take the answering machine and like throw it on the ground in frustration. So when we think about compliance, what are the most common mistakes from a class action perspective? What are the most common mistakes that, other than my father going crazy, that companies make that would lead to TCPA litigation?
I want to start with saying, in a lot of cases, companies that have done everything right or in good faith have attempted to do everything right in terms of compliance still get hit with a class action suit alleging that they failed to get proper consent or they failed to honor opt-outs. But when we talk about the mistakes that like potentially validly could lead to some kind of class action against them, one of the big ones right now is not honoring opt-out requests. So I'm going to focus on texting in this part of the discussion. It does also still apply to telemarketing calls that are either made by a live human or some sort of pre-recorded voice. But texting just kind of is the focus for a lot of folks because it's the most widespread and common. And texts are sent out in such volume, right? Like you don't have to pay a person to make an individual text the way you used to have to pay individual telemarketers to call folks. You also don't even have to have a pre-recorded voice that you have to send out or mechanism for that. Texts are so much easier to send. So that's where we're seeing a lot of litigation. Anyone listening to this, and the three of us, we've all gotten texts where we've said like, I'm done hearing from this company. Like I bought their thing. I don't want to hear from them anymore. You reply, stop, and then they keep texting you, right? So plaintiffs' lawyers are on the lookout for folks that fail to honor opt-out requests. The most obvious opt-out request is a stop text in response to a message. There are other words that the FCC have indicated are per se considered to be reasonable request to opt out, but the law says that people can opt out of receiving telemarketing calls, which have been interpreted to also include texts, in any reasonable manner. So there's lots of ways in which an individual could indicate that they no longer want to receive text messages or telemarketing calls, as it may be. So not honoring those properly, maintaining a good internal do not call list so that you're no longer contacting those people that have asked to no longer hear from you, that can give rise to litigation. The insufficient consent processes are a big deal and have always been a big deal and continue to be a big deal despite the Supreme Court decision in 2021, which to some extent made it seem as though text messages may not actually be covered by the restrictions to get prior express written consent. And I'm not going to go too deep into that, but failing to get the appropriate consent from individuals, which ends up being, in a lot of cases, sort of an own goal, however you want to say it, because a company got a phone number from an order form or something like that and simply didn't ask for specific permission to send marketing text, whereas they could have asked that and gotten a checkbox consent at that point, or they've gotten the numbers from an affiliated or sister company that didn't ask for consent in such a way that it would apply to another company potentially sending text messages. There's things like that. And then they're just plain accidents and mistakes. And when we're working with clients on their TCPA compliance, me, my team, anyone who's working with me, we'll sign up for text messages with that client. Sometimes we'll say, hey, you're really blasting me with texts like 4 to 6 times a day, whereas the consent said something different. Maybe you're only going to receive 1 text a week. And they'll say, that's not what we intended. That's not what we meant to do. So they are legitimate accidents or mistakes, but that doesn't prevent the plaintiff's bar from going after them in some kind of litigation.
So we've heard a lot now about sort of how the TCPA has evolved, and we know that the technology is evolving as well. So we want to ask a little bit about AI and how AI fits into this whole TCPA matrix. Are there gray areas that still exist in how the law applies to these emerging technologies? So if we look at things like AI-enabled voice assistants or AI-enabled messaging.
I would say absolutely. And I think that that's just kind of true across the board of how existing laws will apply to AI is a question that we are asking with respect to many different privacy and data security laws. And in this case, there are a couple ways that I think it might come into play. One is the restrictions in the TCPA, the original restrictions in the TCPA requirements to obtain a certain level of consent had to do with if you were using an automatic telephone dialing system or an ATDS. And in the 2021 Supreme Court decision, where Justice Sotomayor very clearly said, okay, but let's look at what the law actually says. And it says that an automatic telephone dialing system is one that's capable of sending calls randomly or sequentially. So either just randomly calling a large group of people from the phone book or sequentially going down the list of like a number of telephone numbers and calling all of them in a row. That's not what our clients do. Like very, very, very few companies that we interact with or that I've interacted with actually just spray out calls or text messages to anybody in hopes of getting customers. They're normally numbers that they actually got from folks who either ordered something from them or signed up to get text messages or calls from them. They actually did give their number for this purpose. And so whether or not sending those types of texts or making calls using AI will count as an automatic telephone dialing system, which I'm putting in air quotes while I say it, is up for grabs. Because is it any more automatic than the systems that were used prior to AI, that simply you loaded in a list of all the numbers that you wanted to send a text message to from folks who had given you their consent? I don't know. And I don't know if AI may be used in some cases to choose folks to text that may or may not have given their number, but is it random if AI selected it? So I think there's definitely a gray area there. And I'm not saying that I've seen specific instances of this happening, but I do foresee questions like that coming up. And then separately, there are requirements concerning the kind of consent you have to get if you're going to use an artificial or pre-recorded voice. What does that mean? Well, when you're talking about text, there's no voice, right? So the artificial or pre-recorded voice truly had to do with telemarketing calls back in the day that were, you picked up the phone and it was like, hello, this is Melinda from X company calling. And folks were very frustrated because there was no way to opt out of that or to tell this robot to stop calling you, right? So that's where the original restrictions on using artificial or pre-recorded voices came from. But we all still get telemarketing calls like that, even if texts aren't used. And as AI develops, I have little doubt that companies will find ways to use very realistic sounding voices that are, by definition, artificial, right? So if you're using an artificial voice, AI being artificial intelligence, an artificial voice, I think that will end up being litigated at some point.
So taking all that, and that's fascinating, taking all of that for a minute, thinking about, again, the application of AI and all of the gray area constructs that we just discussed, what regulatory or enforcement trends do you see shaping TCPA compliance over the next 12 or 24 months, particularly as a result of the Supreme Court's recent decision in McLellan versus McKesson and all of the state level kind of mini TCPA laws?
Well, that's interesting. So if you're referring to regulatory enforcement as opposed to class action litigation, it's hard to tell because in general, this law largely has been enforced by the plaintiffs' bar and the CTIA, which is a mobile industry association that issues specific rules and guidance about how you can send text messages if you want to use those mobile carriers, which include all of the major mobile carriers and many, many smaller mobile carriers. So it's not so much that the FCC has brought a ton of enforcement actions or even that state attorneys general have brought a ton of enforcement actions under specific laws because the plaintiffs' bar has handled it. But if we want to look at what might happen with two separate issues here, when you're talking about the federal and then the state mini laws, and without going into too much detail regarding the mini TCPA laws or the state level TCPA laws, I'll say that those were enacted, the ones that we've seen that came up since the 2021 Supreme Court decision that I referenced earlier. They've come up and they have specifically addressed text messages and they've specifically addressed those kinds of issues that weren't in the 1991 TCPA. They said, yeah, no, this does apply to text messages. And we are talking about text messages that are encouraging the purchase, rental, leasing, investment in a product or service. They are more targeted at those specific kinds of communications that could still be the subject of doubt, question, litigation at the federal level because we don't know exactly what the TCPA meant by it. And there is now some question as to whether we have to defer to what the FCC meant in its regulations. So the state laws, I can see plaintiffs' lawyers in the states using those state laws where there is a private right of action to more specifically go after calls or texts that are made to individuals in those states, because the state laws are very specific and they're not perfectly specific. I want to be clear that the state laws are not all completely clear, but they're more specific in what they apply to, and thus more susceptible to a type of litigation that would not, try to call into question the original definition of something from 35 years ago. They're clearer with respect to what they apply to, but that might be state by state. In terms of regulatory enforcement trends at the federal level, I think it's really challenging to speculate about what we're going to see. Because even in the short time since that decision, which was at the end of June, or like mid to the end of June, we've seen a number of conflicting rulings at the district court level. I mean, what the Supreme Court ultimately said was the district courts can make decisions about what was meant by the TCPA without necessarily deferring to how the FCC has interpreted it over time. So one of the biggest, say, in terms of my landscape or what I'm dealing with clients, one of the biggest things that the FCC ever said was the TCPA covers text messages. In 1991, there were no text messages. I mean, there were a few people who had pagers, maybe, but it was about calls. And the FCC came along at an appropriate time and said, hey, actually, this also applies to text messages. When it says calls, it means text messages. Well, now we've had several district courts kind of disagreeing on whether actually that is what the federal law meant. And so we are in a very uncertain state right now. I mean, we'll see how those cases progress and whether or not we get more specific rulings about or something more definitive regarding whether text messages should be covered by the TCPA. But we are really in the midst of a confusing moment where I don't want to say it's the Wild West, but we don't know exactly what rules should apply. And I think that the best guidance for a lot of clients is we'll continue to use the FCC's regulations and we'll continue to follow the best practices and rules and guidance that have been set forth by the industry association until we have a specific ruling otherwise. But there's an argument for companies that are more risk tolerant to say, hey, this law doesn't apply to text messages. We're going to give it a whirl. We're just going to do whatever we want without consent. So we're in a difficult moment in terms of prediction. And I do think that to some extent, we might see more attention paid to some of the state laws because they are more specific and they have been written and or updated in the past few years. So there's less potential interpretation on the part of the state courts because the legislature in those states very specifically said what they intended to cover.
So we can basically expect a whole lot of potential change in the federal landscape.
Yeah, it's interesting. Like literally pretty much every other day, there's some new little twist that's coming up. And it is difficult for companies to understand exactly what they should be doing in terms of compliance. And in some cases, it's dictated a bit by the text messaging vendor they're using because the vendor won't work with them unless they comply with the rules that the industry has set forward. So, whether or not what the law says or what courts have said, if the major mobile carriers won't send a text for you unless you follow their rules, you got to follow the rules. It doesn't really matter if I tell them, technically a district court said, doesn't matter. You don't have to do this. If the major mobile carriers are saying you need to actually do this or else we will not send your text messages, then that's a practical reality. So we're in a very interesting space right now.
So it's a little bit like if you want to have an app on a phone and you have to comply with certain requirements that are going to allow your app to be available on a particular device.
Exactly. Or available in a particular app store, right? You have to follow the requirements that to have it be presented in that app store, whether or not that entity that's running the app store is only using the actual laws that apply or the actual regulations that apply. They can impose their own rules. And if you want that app to be in that app store, you're going to have to follow those rules.
So turning a slightly different direction before we get to the last question, I have to ask something fun. I know that you have a serious green thumb. You basically sort of live in a jungle part of the time when it comes to houseplants. And although I'm very good at outdoor plants, I can barely keep indoor succulents alive. And David, well, we don't let David near the plants at all anywhere.
It's bad. It's really bad.
So help us out. What are your top 3 foolproof houseplants for those of us who are a little botanically challenged indoors?
Well, first I'd say like almost any plant person will say you could try a snake plant. And snake plants are also sometimes called mother-in-law's tongue, which is the more derogatory version. They're the sort of spiky, they look kind of like arrows green, sometimes green and yellow, pointy plants. You'll often see these plants like in the middle of a shopping center where no natural light is reaching them. And you're like, oh, that must be fake. And then you go touch it and it's actually real. And those, I mean, my like anecdote about it is during lockdown when we were limited in when we could go into the office, but I would still go into the office in New York City. At one point, about 8 months into that, I went into one of our conference rooms. It's like a, quiet, closed off one with no windows. And there was a snake plant in there that was still doing fine. No one had watered it. It had gotten no light in 8 months and it was still fine. So those are ones that are very hard to kill, and they're a good starter plant. And also they can easily be propagated, but I'm not going to go down that road. Second would be pothos or pothos. They're called the devil's ivy sometimes, Pothos. That's what you're going to want to look up if you want to get one. They're called the devil's ivy because they're really hard to kill, and out in the wild, they will spread extremely rapidly and they're hard to stop. In your house, they also will go very quickly and grow. And from my original pothos plant, I've created, 14, 16. I think I made one for you, Nichole, actually, that lived in your office for a bit until the pandemic when I took it back for care and nurturing. But those you don't even have to buy one. You can just ask someone like me, a plant person, to cut off a cutting for you, put it in some water, it'll grow roots and you can plant it. So pothos are another one. And then finally, succulents. And I know you said that you aren't great with succulents, but people who think, I need to, their succulents belong in a desert. Well, at the end of the day, all that means is they don't need that much water. So a bit of drainage. It is, of course, possible to kill them. And I think if you leave like beads of water on top of a succulent's leaf, it can get burned because the bead of water acts like sort of like a magnifying glass on it if it's in direct sun. But aside from that, most succulents can thrive even so long as they can get light. They can thrive whether or not you remember to water them.
I will say that the succulent that you and I got at the same time this year at IAPP's Global Privacy Summit, that one is still alive.
Yes, we both have managed to keep them alive, and I think they're doing pretty well, frankly. We'll see if they survive this winter, right?
After this, I have to text Melinda my plant photos of shame.
I know. I don't know if I can handle.
In any event, final real question. What is something you would tell every in-house counsel to pay attention to right now?
Well, that's a great question, because if we're going to talk about TCPA, if we're talking about text message marketing, it's like, are they doing that? But forgetting that, just backing away a bit from that, it's pay attention to data collection points, like where is the business collecting data and what kind of notice and or consent are they getting at that point of collection? Because obviously, if it turns out that they're collecting phone numbers because they want to send text message marketing to the customers, then what we've been talking about during this podcast is extremely relevant. Did they get the correct consent at that point? What was the person told when they were providing their number about how the number is going to be used? That's very important. But on a broader scale, in privacy or data protection law generally, it is always important to keep an eye on where you're collecting data and what you're telling people about what you're planning to do with the data. Because in a lot of cases, it isn't that it's illegal to do a certain type of thing with data or that it's forbidden to even collect it. The requirement is simply to provide accurate and complete notice about what you're collecting and how you're going to use it. So I think in-house counsel should really be focusing on that. And in-house counsel is specifically trying to help their marketing team or other teams send text messages, then they really want to keep an eye on where are the numbers being collected and what are you telling people at that point of collection about how the number is going to be used.
Well, thank you very much for joining us today and taking the time. I know everybody's super busy right now, so thanks for being here.
Thank you for having me. It was a pleasure.
If you have any questions for David or Nichole, their contact information is in the show notes. As always, thanks for listening to Baker Hosts. Comments heard on Baker Hosts are for informational purposes and should not be construed as legal advice regarding any specific facts or circumstances. Listeners should not act upon the information provided on Baker Hosts without first consulting with the lawyer directly. The opinions expressed on Baker Hosts are those of participants appearing on the program and do not necessarily reflect those of the firm. For more information about our practices and experience, please visit bakerlaw.com.